Good afternoon, everybody. Welcome to this webinar. We will be switching back and forth with the slides, and sometimes, occasionally, a person will be adding in to give you a bit more information after the main person has commented on a slide. Two things I wanted to mention initially, and one was I'm extremely delighted that we're doing this webinar today. I sometimes have felt that if talking to an audience, people might be saying, what are the lawyers at the School Boards Association saying? And I wonder sometimes when you get presentations from the School Board Association Legal Services, you're saying, I wonder what that commissioner is saying. Let me tell you, in this case, the slides have been worked on collaboratively. And as we've been preparing here, we haven't disagreed on anything. So you're going to be getting kind of the common general understanding and approach to the legislation that's in our province. Now, I need to move to the next slide, which is a disclaimer, which I'm sure you've seen in one form or another today. I mean, we will be giving you general advice, the common accepted rules and practices that are out there. We can't make it an advanced ruling because in many situations, the facts make a difference. So there's no advanced rulings, and obviously we won't comment on cases that are currently in progress in front of the courts or in our office or files that the School Board Association Legal Services are working on. So with that understanding, we'll proceed. Now, I did want to comment about questions. We will try and take questions as we go and answer them at the time that we see them on the screen. If there gets to be too many, we may have to postpone a few till the end. And if after an hour and a half we haven't answered all questions, we'll develop something, a Q&A that people will get sort of with answers to maybe all the questions, but particularly the ones that haven't been answered. So my first component is to talk about the statutory framework. And in this case, there's mainly one statutory framework that's really important, or one piece of legislation, and that's called the Local Authorities Freedom of Information and Protection of Privacy Act. We all call it FOIP or FOIP for short, because it has a pretty long handle. There's two basic principles in this act, and these, as guiding principles, can really help you analyze pretty well any problem you have. And that is that the Act allows the public access to records created and collected by a local authority. And school boards are, under the legislation, a local authority. The other principle that is there, that it requires local authorities, school boards, to protect the information that they have collected, and that is our private personal information. So there's an obligation on them as they collect and use to protect it at all times. In addition to the FOIP, there is another act that is commonly referred to, and it is called the Health Information Protection Act. And again, we short form that to HIPAA. And basically, HIPAA does not apply to employees of a school board. And that would include professional employees who are full-time employees of that particular school board. So whether someone is an occupational therapist or a nurse or a teacher, they are employees of the board. Now, HIPAA does apply to trustees or people who are licensed as health professionals and carry on their own practice. An example of that could be a physician who has his or her own office and under whatever arrangement provides service. This can be, as discussed, a very factual situation as to whether someone is an employee or whether they have their own practice and have an office and a computer and a copier somewhere else. And that's where the facts can become very relevant. But if one receives a monthly paycheck and works in a school facility, I would say then as an employee, HIPAA does not apply to them. Related to that is school boards and their employees are not trustees within the meaning of HIPAA. So there can be a lot of reference, answer lots of questions about HIPAA, but conceptually, the LA FOIP is the act that applies to you as employees of a school board.
We have a question. HIPAA applies to professionals providing services to school boards as contracted service providers.
So sometimes school divisions will have people they contract with to provide services to a school division. So I guess the question would be whether or not, and maybe you've already answered it in terms of being a factual issue, is whether or not that the records created by that contractor would be covered by HIPAA or LA FOIP. And I know from a school division perspective, I would expect that in the contract with the contractor, privacy issues would be addressed within the contract as to who owns the documents, who has care and control of those documents, and that would then be determinative of which legislation would apply.
Definitely. When we had the amendments that came into force January 1 of 2018, there were changes to FOIP and to LA FOIP. And one of the amendments included a definition of employee under LA FOIP, which means an individual employed by a local authority and includes an individual retained under a contract to perform services for the local authority. So either there's that contractual arrangement that already existed, or there's an information management service provider relationship where maybe there's consulting work or what have you. But really, that's hitting the nail on the head. It's knowing what those contractual terms spell out. And I'll talk a little more about possession and control of the records in a little bit that I think will provide a little more background on this.
And you have to keep in mind that the word contract is an extremely broad word. One can have a contract to teach for a full year at a school board. I would say basically then you're just like an employee. Yeah. Or you can have a contract where you provide a service when somebody comes to your office and you never appear on the school premises. So the details of the contract are extremely important. Just to finish this off, health information or any information that is in records created by the school division or any employee of the school division are basically records that are in possession and control of that school division and are governed by LA FOIP. Information, such as health information that comes from outside, is received by the school division or received by an employee of the school division. Again, once it comes into the control of the school board, is basically personal information and is governed by LA FOIP.
Just to wrap up in this section as well, I think one of the slides also indicated that in addition to LA FOIP, there's the regulations, and HIPAA as well has regulations, but it's not applicable in this case. And when it comes to LA FOIP and HIPAA, both are quasi-constitutional laws that generally trump other laws. But that doesn't mean that you don't take the sections, the provisions of those other laws into consideration. And I'll hopefully provide some examples of those later on. So now we're on to records. And when we're looking at LA FOIP and applying with the law, this slide and the next one are of eminent importance, and making sure that we all have these concepts with our head clearly wrapped around them. Because a record is any information in any form or format that the local authority, in this case the school board, and that includes, the school division and everybody that works within it, that's one silo, all of the information that they've amassed in any form or format, whether it be paper or digital, it could be a video or audio recording, it could be a sticky note. All of that information and how it's brought together creates these records or documents that an individual can make an access request for. And there's a formalized process. We don't have time to get into it today, but there is a 30-day clock on that. And I'll talk a little bit more about what it means to get access to these records. But in terms of the records, we talk about them in terms of possession or control. So possession is if the records themselves are in the physical possession of the school division. So someone that works there, have them in their physical possession that they can actually touch them. It's in your computer systems, it's in your file folders, maybe there's a text on your phone, and that information is accessible to you. There's a measure of control that's important, because if it's information that you shouldn't have had because of your mandate and the services that you provide, maybe it was unsolicited, it was a mistake that it was sent to you, a privacy breach could arise if in fact it's somebody's personal information and you shouldn't have it. So in those cases, you should be returning or destroying the information at that point. But if you're uncertain, it's always best to ask, that LA FOIP coordinator, the person that has the expertise within your school division. But what's interesting too is what I found in the last 15 years doing this work is sometimes professionals in the field think that there's two sets of records, that there are records that are officially that of the body, the local authority, and then there's my personal records, that maybe I take handwritten notes when I go to meetings, or I have my own emails in my Outlook folder. But if it's about the work that we're doing, it's work product, and it still would be records responsive to an access request if one came in the door. So the next concept that's really important is defining personal information. So records may or may not contain personal information. And privacy interests come into play, of course, when somebody wants to see the information of the data subject to whom it doesn't apply. And we'll talk a lot around the rules around collection, use, and disclosure coming up shortly. So how do we define personal information? A couple of different things to keep in mind. First, we have to have an identifiable individual. And we also have to have information that's personal in nature. In Section 23, Sub 1 of LA FOIP, there is a list of data elements. These are examples. It's a non-exhaustive list of what is considered to be personal information. And some examples include family status, race, disability, education. And what's really interesting one is views or opinions. And we think in terms of professionals, we offer our views and opinions about others all the time. But that's the personal information of the other person, not of the author. So if there in fact was a decision made around collection, use, or disclosure, it must be in compliance with LA FOIP. When it comes to recording opinion materials, it's really important too to be as objective as possible. It's the subjective comments that sometimes people get their backs up if they see them, and maybe they're going to make some requests for correction or change, or they're going to make a complaint to our office. And the last thing is, when we're dealing with personal information, always think and ask yourself the question, would it be sufficient to use de-identified information for my purpose? Would it satisfy it? And de-identified is stripping away certain parts of the information so that others cannot readily identify who we're dealing with. So an example, a male aged 45, grade 8 education, who's HIV positive. Who are we dealing with? It could be anybody in the world. But I add one more data element, and it's not even specific to any person other than the fact that that person's sitting in this room. Well, if there was one 45-year-old male sitting in the room, we have an identifiable individual. So it's always taking that into consideration, even if there's a conversation being had at the water cooler. If the data elements are unique enough, you don't need name for there to be a privacy breach.
So as part of looking at this area of records, it's important to understand all records created by employees become subject to LA FOIP. All records created by employees as part of their employment belong to, are owned by, are in the care and control of, whichever way you want to say it. They are the subject of control by the school division. And there's a case that's out of British Columbia. It's a few years ago from 1996. And it is, while it's not binding in Saskatchewan, the principles in it would be the same type of principles that would be used here in Saskatchewan. It's the School District Number 2 of Cranbrook. And this involves the notes of a school counselor, and the individual had made a request to the school to access the notes of the school counselor. And she had she kept her raw notes in her own notebook at home, and she just brought them to school when she needed to do so. It was the counselor who argued that her notes were not in the custody and control of the school district there. And therefore, she said, I don't have to disclose them to the school division. Well, the BC Privacy Commissioner didn't agree with that position. And the Privacy Commissioner found that, well, the counselor is an employee of the public body. It's an employee of the school division. And she's creating those records in the course of her employment. She was going to a couple different schools. And the definition of records under the Act, it's similar to the one that we have here in Saskatchewan. It includes papers and everything that could record information, basically. And these records are the product of an employer-employee or contractual relationship. They belong to the school division, and they are records that are are considered under the care and control of the school division, and thus are subject to LA FOIP, which is really important to understand, especially for health professionals, and especially those of you that might go from school to school and keep varying ways of records, keeping electronic records, everything, every piece, every record that you create belongs to the school division. You have to follow LA FOIP rules, and you also have to follow the policies and procedures of the school division as to how you deal those records. Another comment was made by the Privacy Commissioner in that case in British Columbia, and I think that's appropriate for us to sort of think about too. It said that it was inappropriate to keep raw notes and files in her own home. They can be maintained separately, counselor's notes, and we'll talk about some of the privacy considerations there, but they need to be kept secure. And here they talked about keeping it in locked files and so on. But it has to be kept secure in a way that is compliant, again, with the procedures and policies of the school division. This is not a decision that each individual makes. This is a decision that's made by the school division, and employees and contractors with the school division must follow those procedures.
Great. I think that's what's really important in this context too, is when we look at those terms, possession and control. So control kicks in when somebody else has the information, maybe it's off-site, a contractor has it, but the school division has the right to manage. And if they need that information back and they have the ultimate responsibility to safeguard it, in addition to all the people that are working, with those documents, that there have to be those safeguards in place, which we will talk about.
And that's exactly what happened in this case. The school counselor had them in her personal possession, but the school division had the right to request those from her, and then would analyze the LA FOIP request and respond to that request in light of the facts of that case.
Exactly. I think this is where things become even more challenging as technology advances and how we communicate, how we do business. So we've shifted from paper records to a digitized society that we do a lot now via email. We even have moved to text messages in certain respects, and we can examine and discuss that issue a little bit later on as well. But with personal devices, and this is something that I'm not sure for every school division if they have specific policy on this, but often it's a bring your own device situation where it's a laptop or a tablet, maybe it's your iPhone that you're bringing and conducting work, maybe from a personal email address or sending text messages with parents. And what may result is, well, these are still records that should be in the possession or control of the school division, but how are we capturing them? How are we protecting them? So it's looking at making sure that if you have those practices in place, that you sit down and you have a discussion about how LA FOIP is going to be taken into consideration as a whole. So the next one too, and you'll see at the top of some of these slides, we say ownership of records. We're just simplifying possession and control because, it really comes down to that in simplistic terms, is who is responsible for these records. And when an employee leaves a division's employ, and we see this all the time, regardless if it's a local authority or a government institution or a trustee, is there sometimes a misconception about, who takes those records. And again, this is work product that was developed in the course of employment with that employer, and the information needs to stay with the employer. And this is why things like record retention disposition schedules come into play. They're really important because they help to tell you what information should be kept and for how long. But it does get more challenging when you're looking at personal devices, What are you going to do with those text messages, for instance, or emails that are on your personal email accounts? So it's that transition and shifting that information back to where it needs to be. And it comes down to records management practices. And again, understanding what the obligations are on you. And the division has to make sure that the records, the information that you're working with when it comes to personal information of students, parents, families, even coworkers, is that it's only shared and made available to those that have a need to know. And I'll talk about the need to know coming up pretty quick too. So now I want to get into the rules around collecting, using, and disclosing information. And I'm going to start with collection. And collection is a data transaction. It's taking the personal information and bringing it into the organization. It's generally defined as to gather, obtain access to, acquire, receive, or obtain. And it's done in a number of different ways, but once you have it, then you've got to follow the rules of LA FOIP, and you only collect what you need for the purposes of your mandated services that you're providing. And these, by the way, are privacy principles that we're going to revisit throughout the afternoon because we're detailing each one. So collect what you need. The two privacy principles I wanted to introduce and talk a little bit more about was the need to know principle and data minimization. Need to know is not nice to know. For every individual that's working with personal information, you have to be able to demonstrate that you only are collecting the information that is reasonably necessary for the purpose. So if 5 data elements would suffice, then you don't need 6. Data minimization is that concept, which is only that minimal information shared with a person that has a need to know. And it really comes down to people's job descriptions. If someone's, the bus driver, they may still need some personal information of students, but they're not going to need the same amount as the psychologist. And it's for the purposes of education, or again, if you're a healthcare professional, you have your own mandate to which you're providing services. And when it comes to the information that you're collecting, you need to make sure it's as accurate and complete as possible. And that's important too, because if you're making decisions about an individual and what they need, you want to make sure it's based on accurate information. We're not spending any time on this, but there's also a right of correction that the individual has, and there's a process that's laid out in LA FOIP that can be addressed on a case-by-case basis. And lastly, when you are collecting, LA FOIP requires that you do it directly from the subject individual and you inform them to the anticipated uses and disclosure of that information. There are some exceptions to the rule. Indirect collection would be from another source. And generally, you would do that if you believe the information that you would receive would result in inaccurate information, it would defeat the purpose, or it would prejudice the use.
So from a sector perspective, what you need to collect as a school division will depend on what is required under legislation, so specifically the Education Act or its many regulations. The Ministry of Education may also have requirements that it sets out in policy or legislation. We also consider individual school division policies, procedures, and forms. So every school division has its own policies on various topics, whether it's matters relating to employees or students or a variety of different areas. But so we look at individual school division policies and procedures as well as the forms that they may have created. When you are creating forms, you need to think, is this form appropriate? Is everything on the form required for current purposes? So the piece just mentioned about in the previous slide about thinking about what it is that we need to collect. Those are the things that we consider when we're creating forms and reviewing forms. Of course, your professional judgment is always necessary to be exercised, particularly when you're doing assessments or other things. You need to be able to apply your professional judgment to make sure that you are collecting only what you need. When you are collecting information for professional assessments and reports for school division purposes, it's really important that you let the parent, and depending on the age and the maturity of the student may also need to know why you're collecting this information for education purposes, how this record will be shared within the school division, but that it would only be shared with those who need this information to do their job, and that they would be able to access the record as well in the future.
I think this is an important point that you're making, because I think a lot of the problems that we see are when parents don't understand why they're collecting it and what it's going to be used for and who it's going to be shared with. They might say, I didn't know that the teacher in the classroom would get that information. So I think that's especially the kind of sensitive information that the health professionals working in school might get. So
Yes.
yeah.
When we are receiving records, particularly from external resources, so that could be maybe there would be reports perhaps provided to the school division from child and youth indirectly from parents perhaps, or there may also be reports received by the school division as ordered by the youth court in youth court processes as examples. We will sometimes find that these reports have conditions imposed, and we will need to respect the conditions imposed and discuss with the creator of the reports the conditions so that we understand what it is that we can or cannot do with them. We try to avoid accepting conditions when collecting information because it may affect how we use that information within the school division proper. So, for example, if we receive a report from Child and Youth that says this is not to be disclosed except as authorized by the writer, that can perhaps affect how we share it within the school division. However, when we do that, we discourage creating or accepting conditions when collecting information, and we encourage that we try to keep in mind the purpose of these conditions, but recognize that the whole point in having access to this information is to benefit the child. So there's no point in having a report if we can't use the contents of that report to benefit the child in their education. If you do accept records with conditions, please confirm to the provider that the condition is accepted subject to disclosure being required by law. Ensure that we understand the conditions that are being requested and that we understand them, and ensure that these conditions are communicated and followed by the school division and its staff.
So the next topic is security. So back to our principles of privacy. Once collected, make sure your records are secure. We don't talk just about security when we're talking LA FOIP or any privacy law. The more general term is safeguards. And when we look at the language of LA FOIP, there is explicit language, duty to protect that personal information that's in your possession or control. And there's a number of different ways in which we accomplish that. It's by having what we call physical, administrative or operational, and technical safeguards. And specific examples of the physical ones are locked doors, locked filing cabinets. Operational or administration is looking at your policies, procedures, training, orientation. And then on the technical side, there's so many different ones, especially with the advancement of technology. You can have passwords and firewalls, and you can, decide in advance which individuals have access, user rights, so they can get access to different file folders on a shared drive, for instance. So it's looking at the totality of your systems and what kind of safeguards you can build in order to protect that personal information. And of course, it's really important to be aware and follow board procedures and policies. Part of what we do in the course of an investigation is to see, A, are those in place? B, were the employees educated and aware that these policies and procedures existed? Were they followed? And lastly, if all of that was in place and it still fell down, what kind of changes need to be made? And we kind of go forward from there. And this obligation, this duty to safeguard, extends past just the computer systems, paper files. It's also those mobile devices, personal devices that we were talking about as well. As long as we're dealing with personal information that's in the possession or control of the school division, it needs to be sufficiently protected.
An example of that would be when somebody's carrying their laptop containing all the students' personal information and they leave it in their car overnight and then they discover that it's been stolen the next day. So that would be a practical example of how this slide and the considerations that you're discussing.
And it happens pretty often.
Oops, that's not good to hear.
There is another question. So do we follow board procedure ever if it is in conflict with FASW guidelines?
About following board procedure in conflict with, I'm assuming that's
The Social Worker
Social Work
Association.
Association. Again, there'll be a factual component to that, and but I can certainly say that both the board policy and the guidelines must be consistent with LA FOIP Act and regulations. And so if there is a conflict, then in these kind of areas, we would look at LA FOIP and the guidelines, and whatever they say goes. So it's not necessarily but generally speaking, as an employee, you start off following your board procedures. If you have a conflict with your own professional association, and we as lawyers deal with that as well, then you have to have the discussion with your employer, or you have to make a decision about how far you take that. And that's a whole other different discussion. But in terms of LA FOIP trumps both policy and
Because
guidelines.
it's a quasi-judicial piece of legislation, so it's paramount to other legislation.
And in addition, this contemplates that someone's asked to see this report. Ultimately, it's the head of the board, probably the director, who makes the final decision as to release or not. So I think the buck does stop with the board. I assume all of you would agree with that.
Yes. Yeah.
Sounds good.
Or might stop with their lawyers if the lawyers are giving them advice. But
Yeah.
yeah. So in terms of looking at the safeguards for specifically health professionals, they often will work at a number of different schools. So, just some suggestions on addressing some of these safeguard issues is if you can work remotely as much as possible so that you're not storing records on that laptop or in a box of files in the trunk of your car. Don't leave anything unsecured in your vehicle at any time. The more you do that, the more the risk rises. And going straight home with records, I mean, people do that. They stop at the grocery store, leave their car unlocked, and the next thing they know, pages are scattered across the parking lot. It can happen in a fraction of a second. And then be scrupulous about your electronic protections. Such as passwords and encryption. We're all can be lazy people, but we can't afford to be lazy people when we're protecting the private information of students. And work with your IT department, not against them. I've heard many complaints from IT. We're just trying to do what we know we have to do. And at the same time, I know teachers and health professionals are trying to be creative. They're trying to be supportive. But we do have some basic things we have to do to avoid risk, to protect vital and personal information of the people that we have to care about. And really, information collected by professionals is usually considered by students and parents to be the highest confidentiality. So not only is there a significant risk of harm if there's a breach that occurs, but, frankly, from a practical perspective, there's a heck of a lot bigger chance that somebody's going to make a complaint or do something about it if this kind of information is breached or released. So again, a high degree of caution. You have the care and confidence of the people you deal with, and that's the last thing that in these kind of professions that we need to have happen. So your board will have certain, and not every board has a great deal of policies or procedures on this. Failing that, use common sense. Protect it the same way you would protect the information of your child or your own information.
Okay, the next privacy principle is appropriate use, access, and disclosure of records, specifically ensuring use, access, and disclosure is appropriate. So whereas I introduced collection as a data transaction, so is use, and we'll start with that. So use it includes reference to or manipulation of personal information, And it comes back to the silo again, to the school division, to everybody that works within those walls. And LA FOIP spells out what the rules are when you can use that information internally. But again, that's within your walls. If you go external outside your walls, that's a disclosure, which I will come back to. And sometimes, and this is where things get a little bit complicated, someone will say, well, I have access to those records. Access is utilizing, right? So it's the same kind of transaction. Access to information is a request to access copies of records or to view them. So we have to be careful when we're using the word access. But right now I'm talking about use. So once a record is received or created or compiled by a school division, because sometimes you're not just getting a full document or information from someone from the outside, you're actually generating it yourself internally. And again, if you've collected it legitimately, then you want to use it in order to provide your services, your mandated services. And as long as you have individuals that are tasked with those responsibilities, they have a need to know, and you respect the data minimization principle, and you can share that information internally to the extent that you need to. But what's interesting is it's really episodic in terms of making a decision who to share information with in any point of time. One individual may need 3 data elements, in order to provide a benefit or a service to an individual. Someone else may need none. So it really comes down to determining that on a case-by-case basis before the information is shared. And you can use that information internally if it's also consistent with the purpose for which you've collected. And that's something that is really close to the original reason why. An example we use in healthcare a lot is, you collect information, personal health information, for diagnosis, treatment, or care. But consistent with that would be billing, right? You still have to get paid. So then the information, limited amounts of it, have to be used for that other purpose. And outside of that, if you don't have those 2 circumstances, you need consent. But there are exceptions to that, and I'll come back to it when I talk about disclosure. So one school division, and this is starting to move outside of use and move to disclosure, is when one school division, the personnel need to share with another school division. But LA FOIP does recognize, and that can happen without consent.
So basically, there was actually a former decision by the former privacy commissioner, and as one of the commentaries in that decision had said that when a school division shares information with another school division, it's sharing it for the same purpose. So it's a use that's consistent with the purpose the original school division gathered the information. So once you've got it as a school division, you can share with another school division without parental consent, as long as it's being used for the same purpose for which it was originally collected. And I think that's an important confirmation of the fact that that's the practice in school divisions. Certainly children move from place to place and their cumulative folder follows them, but also copies of reports, assessments by professionals can also follow them. So really, when we're talking about the use within the school division, we have only those persons that need it can use it, and again, the minimal amount that they need for their job. This includes the copies of the reports, assessments by professionals. If an occupational therapist does a report, and if the classroom teacher needs to know a portion of that report or the portion that's necessary can be shared with the classroom teacher. That does not require further consent. Once the school division, remembering what it's the care and control by the school division, it's up to the school division to ensure that it's only shared with those people who need it. But once they've got that document, they make that determination. They don't have to go back every single time a new teacher's hired, a substitute teacher comes in. We don't need consent from parents to share that information with additional employees who might need it to do their jobs. So again, the real key question is, does this employee need it in order to perform the services necessary to provide education services to the child? And when I say education service, I mean all those other services that we also supply, the support services from occupational therapists and so on. Copies of those reports can also be shared with contractors if the contractor requires that. Again, it's up to the division to ensure that there's appropriate agreements in place to protect the confidentiality when that contractor has it, and to ensure that the contractor only receives what the contractor needs in order to perform the services required. So again, this is not something individuals in the school decide. This is something you work with either your procedures policy or your supervisor to ensure that the confidentiality, privacy, and the LA FOIP requirements are being met. There may be instances, however, because we're dealing with professional records and we have specific types of professional records that maybe it really can only be understood or should only be shared with other like professionals. And probably the one I'll use the example of is counseling records, highly, highly confidential. Rarely shared subject to disclosure, rarely shared the notes of a counseling session with other professionals. Let's say a child moves to another school division. Those counseling records can move to the other school division on the principle of use, but the caveat to that is it only moves to the counselor in the new school division, because that is the only person who would need access to those records in order to perform their job. So again, it's not open field on the director to just say, oh, I think everybody should have. No, there's some basic principles involved here that can restrict who has access. So again, it's that use. Do you really need it to do your job? And that I emphasize that because I've attended conferences where they say the worst offenders or the highest risk comes from people within an organization accessing information that they shouldn't access. You have to worry about that more than you have to worry about outside hackers. Yeah. And so this is what I want to emphasize. Only those that need this should have access to it.
Questions? Do we need third-party release to share the professional documents?
No.
Not within
No.
school divisions. Not within school divisions.
Yeah, if it's come to the school division, within the school division, it's the principles that apply. We do not need written consents to do that. Once we've gathered it legitimately gathered it, then we can use it inside the school division without further consent.
Third-party consent, that's actually an odd statement for me, because consent belongs to one person and potentially two. I will talk about consent some more, but consent is of the data subject, the information to whom it belongs, or their personal representative who might be a parent or guardian. So a third-party consent would not be valid.
Yeah, it's just, it has to be the person whose information it is that gives consent, if consent is needed. In this case, there is no consent needed. And the second question about parents requesting records.
What if parents request records that need to be interpreted by someone with professional credentials?
Well, I'm about to talk about access to records. So if you hold on just a second, I'm going to start covering that, and then my colleagues will jump in and hopefully elaborate a little bit more.
If we could just remain on this slide and talk about raw data, because there was a question about commercial information.
Oh, yeah, that's
commercial
right.
sessions.
Sorry.
Yeah,
So that would
it sort
be
of ties
this is
up with
the
this one,
opportune
too.
time to discuss.
Yeah.
Raw data is not something that would necessarily follow the file. It would possibly, it may stay on the file in the original school division, but that would be something that would be negotiated between the professionals.
This is one of those areas we talked about getting things on condition. If there are conditions on the raw data about how that will be used and you've accepted it, then you have to abide by those conditions, and that may limit it. Again, subject to applications that may end up under LA FOIP, but really as a school division, you should consent to do those. In most cases, you can send them along with the entire file if they're subject to the same, and this ties in with this other question, subject to the same conditions in the new school division. And if those conditions are that only those professionals should have access to that data, and you maintain that, you can pass that information along. So a lot will depend on the particular conditions under which that was accepted. So unless those prevent it, you may have the same conditions apply in the new school division. when you're dealing with the interpretation of records, well, as we'll say, we'll talk in there, but these two things overlap. You can carry out your professional responsibilities as long as they don't conflict with LA FOIP. And in terms of, yes, sitting and interpreting with people, yes, you can do that. But if they actually do a request under LA FOIP, we're going to talk about that in a minute.
So it might be helpful to think of something a little bit more specific like the WISC, right? So the WISC would be subject to copyright as well. So that would be some of the conditions that we need to consider.
So access to records of parents and students. This is not access that I access the records for a use, internal use of the information. This is the access to information request. And with access to information, it doesn't always have to be formal. It might just be a verbal request. But all of the rights and the ability to complain to our office, they're not at play until there actually is a formal request and access has been denied. And so this section is all around that formal access rights of the individual to records. So, of course, the LA FOIP provides that right of individuals to make that request for information. And, if it's a formal request, the local authority has 30 calendar days in which to comply. And there's two forms of access. One is to the general records that anybody can ask for. The defaults provide access unless there's specific and limited reasons to withhold. We're not talking about that today. Rather, we're focused on the request to get access to personal information. And, we're basically talking about students, but there also might be family information involved in these records. So because the default, it's my information, I should get access to it. But the individuals that work within the local authority, they're the data stewards. They're the ones that are ultimately there to provide services to make sure that these records are there for their entire life cycle and that they're able to have that continuity of service. Like we said, if we're shifting from one school division to another, having those records follow along. So does that mean I get everything on file? Maybe, maybe not. There are, again, limited and specific reasons in which information could be withheld from the data subject, but you would have to go through and sever or mask. So you release the bulk of the information, and what limited information that needs to be withheld is withheld. An example of when information might be withheld from an individual is if it could threaten the safety or physical or mental health of the individual. I'll come back and talk about this a little bit more under disclosure because you can withhold access to the individual, but there's also opportunity to disclose if for the same reason, if it was necessary. So again, access is to the data subject and it might be that of the student. And it's the right of access. It's not only to the cumulative files, but everything else that we talked about in the possession or control of the local authority. And we've mentioned a couple of times, it is a copy of the record or coming into view. And with those amendments that came to LA FOIP in January 1, it also is maybe a sit down so that codes, abbreviations can be explained if in fact, the child or the parents, they're confused in terms of what is recorded on the records that they've been provided. So that is an obligation of the local authority to make.
If we go back to that question that was asked previously about professional credentials and only being asked to look at that, what LA FOIP allows is an actual copy.
Yes.
Of the information. So, and you can't, and schools have a tendency to say, well, this is an important thing. We just sit and we'll explain it to you. That's what we used to do. Not since LA FOIP. The person's entitled to, now what you may do is offer to sit with them, work through it, interpret it, give them the information. If that report, that let's say an ed psych report, has attached to it some pieces that are copyright, there's this, in terms of disclosure, we can hold that back. But the rest of the report, every other page, it's subject to giving them an actual copy of the record, not just the chance to sit there and read it in your office. It's the actual copy of the record, subject to anything we reserve for copyright or other issues.
Well, and that's interesting too. Our office has had the opportunity to look at the Copyright Act, and there's actually provision in there that doesn't interfere with access
Okay.
rights under these types of laws.
Yeah.
So copyright shouldn't interfere. But that's something, again, that we could take you through the particular language to show you
Yeah.
where that is found.
So it would depend on the particular documents and the yeah. So generally, yeah, they get it. If it's your stuff, you get it.
Right. And it's important that you said that too. It's not a summary. You have the individual has a right to source documents.
Okay.
And when I mentioned earlier too, it's important to be objective and not subjective. Writing down that someone is difficult or problematic or challenging to work with. There isn't any opportunity under LA FOIP to sever and remove that just because maybe you have remorse that you put that in the documentation. So think twice, write once. So this last slide is about the student themselves. And it does get a little challenging, and we're going to spend some time on the topic around the student, and we know they also sometimes have adult students. In the event that we have an 18-year-old, they're on their own. They are of age, and unless there's some competency issues, they're the individual that can exert their right or powers under LA FOIP, including giving or revoking consent, but also making an access request. And I know we're going to talk about others that kind of step in and act for that individual as a personal representative, but I'll let my colleagues do that.
Well, we consider privacy as kind of on a sliding scale. So the younger the child, the more privacy or opportunity to access by parents or guardians increases. But the older the child gets, their privacy rights and access rights increase as well. So in this slide, we're talking about adult students. So we have students in our facilities who are 18 and older. So if they are capable of giving or refusing consent, there is a legislative presumption in the adult guardianship legislation that they have the competence to act on their own behalf. But the adult guardian, their role may be more specifically defined in an agreement. Perhaps the student is given a power of attorney, or also there's also legislation that permits the parent to bring an application to be deemed a guardian and exercise certain powers. So that's with respect to adults. So then we talk about those in-between students, those students that we refer to as a mature minor or an informed minor. These are students who are under the age of 18 years. And these are individuals who are smart enough to understand what's within the records. They're competent, probably quite articulate, and they can understand the process and implications of their decisions. They are able to access their own records without parental consent, and they are also able to give informed consent to access to third parties to access their records. So, for example, this may be an individual is charged as a young offender, and their defense counsel may want access to their records or certain records. Or perhaps it would be external healthcare professionals, or perhaps children whose parents are involved in child protection proceedings. The Counsel for Children may request access to records by this route. So when we look at the concept of an informed or mature minor, we look at each individual student and we look at their maturity. So some students are mature enough at the age of, say, 12 or 13 years old to start making decisions about accessing their records. And of course, it's on a case-by-case basis that we evaluate each child. By the age 14 or 15, most students are considered to be able to consent in a variety of situations, and certainly by 16 and 17, almost all students are able to make decisions regarding accessing their records. The concept of independent minor is as a student who would be perhaps about the age 15, 16, where social services has permitted them to withdraw from parent care and perhaps are living independently in their own apartment, perhaps. So an independent minor is another category of students who would also be considered sufficiently mature to give access to records and providing consent regarding their personal information. So an example of this student may be a student who is estranged from their parent, so they don't live with their parent, don't have any contact with their parents, are not interested in having contact with their parents. They are often financially independent. And these students may request in writing that the school division not provide access to their parents or their guardians. And so if the parent or guardian is seeking access, then we have to consider the views of the student as well as the privacy implications in Section 49D. So looking at Section 49D, this is the piece of LA FOIP that we consider when assessing when to give access to students, as well as to their guardians. So Section 49D talks about where a student is less than 18 years, the student's legal guardian may get access to the student's records where, in the opinion of the school division's head, the exercise of that right or power would not constitute an unreasonable violation of the student's privacy. So whenever we receive a request by a parent or guardian of particularly older students, we look at Section 49D to determine whether or not this information, when released, would violate the student's privacy. Now, with respect to legal custodian, we take a look at the family law legislation. So we look at the Children's Law Act as well as the Divorce Act. And in those legislation, it talks about parents who have joint custody. The Children's Law Act defines when there's a presumption of sole custody, or actually both legislation, the Divorce Act and the Children's Law Act, talk about sole custody as well. Parents who have joint custody or sole custody have the right to make education decisions for the child. They're entitled to exercise the right of the child under LA FOIP, and the signature of one parent is generally sufficient for release of information. We don't need both signatures. So it is quite common in family law litigation, for example, for a parent to request access to their child's records so that they can be used for litigation purposes. And that is something that would be addressed to for the guidance of the school division's privacy head to determine what information should be released, and they would do an evaluation based on Section 49D of LA FOIP.
So when we're looking at custody and access, a parent who has sole custody can make decisions, or a parent who has joint custody can make decisions for a child, but a parent who has access also has the right to access information. They can't make decisions about education. They can't give consent on behalf of the child, but they can make an application to access the information of the child. And the Section 49 applies to every parent, not just those involved in custody and access situations, but any parent. That final filter is always, if we release this to the parent, would it constitute an unreasonable invasion of the privacy of that individual? In terms of getting information about the child, informal guardians may also be able to apply Section 49. Informal guardians, we want to be a little bit careful on that. Are they, what's really their relationship with the child? What role does this person fulfill? How does the child perceive them? How long has the relationship been in place? But we do have lots of situations where children live with grandma or auntie and mom and dad aren't around. We're certainly going to allow those people that are looking after and have the actual care and control of the children to have access to the information they need in order to support that child. So they would be able to sign the consents that were needed under LA FOIP in order to share information, and they certainly would be able to access information that's necessary in order for them to help the child with the education processes.
There's another question. What about students 16 to 18 with cognitive ability?
Usually we accept that students that are 16 to 18 have the right they do have the right to access their own information. It also works for sort of the corollary of that, is that if they say, I don't want my information to go to my parents, then we have to seriously take a look at that. Now, it doesn't necessarily mean we won't share with the parents, because Section 49 says we can share if it would not constitute an unreasonable invasion of the privacy of the individual. An assessment has to be made there. If the kid says at 17, don't tell my mom, don't give my report card to my mom, well, is that going to be an unreasonable invasion of his privacy if we share it with mom? Some circumstances, factual, it may well be. In others, no way. So the analysis has to be done.
Yeah, and I think what really helps is when we're talking Section 49, we're talking about somebody else stepping into the place or the shoes of the data subject. But regardless, the school division, the local authority, the people that are the delegates of the head to make these kinds of decisions, they also have to look at the disclosure rules, and maybe in certain circumstances, and it would be a disclosure to, another individual, maybe mom and dad or a grandma or whoever, if it would be a benefit to the subject individual. And I know I haven't gotten to disclosure yet, but these are the circumstances that are already contemplated by LA FOIP, and allowances can be made as long as it's being done in good faith.
Yeah. If it's a safety issue for the child and the parent needs the address, we'll usually say yes. Sorry.
The question said someone between 16 and 18 with cognitive abilities, and then I think you're back into the sliding scale. For a totally aware, mentally alert student between 16 and 18, you're going to probably treat them as a mature minor. With cognitive abilities, you're going to have to look at the facts. And it gets even more complicated with people with cognitive abilities. Today, they can be operating really effectively and efficiently, and tomorrow, for some other reasons, they're not as cognitively aware. So we're really starting to get into factual situations where professionals have to make assessments.
True.
Yeah.
And it's about, and I think the point made about how beneficial is this to the individual. There are times when we make disclosures, and the disclosure may actually cause child protection concerns. So we have to be mindful that although we may mean well, we have to consider all of the elements in individual cases, and having a discussion with your office's privacy officer may be very useful to flesh out the situation.
And that leads us to the slide here about accessing is always subject to whether it's unreasonable invasion, and it's the opinion. So it's the opinion of the head or the LA FOIP coordinator or the director at the school division. That is the person who makes that determination, and you have to, in making that determination about whether to release it, you have to be able to show that you've exercised your discretion appropriately if you're going to refuse it or if you're going to give it in a situation where it's a disputed thing. So it's a thoughtful, reasonable analysis that you can back up. It's not just a knee-jerk, oh, they said this, therefore the parent asked for this, so we're just automatically giving it to them. A word of thought is really what you need to put into this. Students under 18 that are estranged, I mean, we've seen situations where they really shouldn't be given the information. But if there's safety, we always say safety trumps everything. And I'll just, and not all information of students is released at any time. And there's a case here that I'll maybe just run through very quickly about counseling records. This one took place in Ontario. And this is a case where a parent was involved in a social services application for apprehension of the child, who I think was about 14. And the parent wanted to get access to the counseling records of the child to be able to show that this child was not having any problems when the child was with mom. The court said no. So even in a case where this would be maybe helpful, or the mother certainly thought was helpful, the court analyzed and weighed the privacy interests of the child versus the relevance and necessity of that information for that particular court case. And we've seen several of these in Saskatchewan where we've appeared, and the courts have said, no, we're not going to release counseling records because they balance the privacy interests of the child versus the relevancy of the materials to the particular court case. And I think if you take a bit of time to read the quote there, I won't read it through all now, but you'll see there that the court placed value, not just for this child's individual privacy, but the privacy of other children who would maybe be discouraged from attending the counselor if it was known that these kind of things could just be accessible very easily without that thoughtful process. So I think that applies. It's a counselor here, but I think a lot of the folks we're talking to today, this would also apply to them. And so they said a child's entitled to enjoy a high expectation of privacy during communication with counselors, and that would apply to other professionals.
And just to mention that this doesn't just apply to family law or child protection cases, that we also deal with the issues of criminal law matters as well. So accessing youth or student records for criminal process is a consideration.
So now we're going to shift to disclosure of records to third parties. So disclosure is the third of those data transactions. And the disclosure is you've lost control of the data because you've now given that personal information to somebody outside, somebody external. And unless there was some sort of conditions placed, this information is now going to be used by, the other entity, individual, organization, to the extent that they've decided to do that. And what's important, and the commissioner did a blog on this a while back, was on the two sides to this, is that there has to be authority to disclose on your part, but the other party has to have authority to collect. And, when in doubt, work that out, challenge it, ask, look at your own legislation, talk to your privacy officer. And if you're not satisfied, you're not comfortable, then don't share the information. The thing about disclosure is, for the greatest extent of disclosures, it is discretionary. Very few are actually mandatory, and one might be in the event of Public Health Act, or if there's a duty to report abuse of a child. So in terms of some of the specific reasons or circumstances in which you can disclose without consent, is very similar to what we talked about earlier, is that consistency with the use. Why did you collect the information in the first place? Now we're sharing with another school division. That is a disclosure. And so it's that continuation of the need to know. And you can use the information for any purpose you can disclose, and vice versa. So again, it's nailing that down before the information is being released. And if you don't have authority under LA FOIP or in the regulations, or another law doesn't give you that authority, then you do need consent. So a third party sharing the information is, with a third party, is anybody other than the data subject, the individual, or the representative. And again, if it's a use, if it's sharing it within the silo, within the employees that work within the school division.
So some examples of third parties, and we've got a list here of, police, Ministry of Education is a third party. We can share information with them under a specific section of LA FOIP, but they're a third party. Regulatory bodies, media, the province, youth and advocate, lawyers, the individuals, Voices of Child reports or pre-sentencing report, health authority, other organizations like Community Living, Autism Resources, all third parties. And you need to either have consent or be able to point to a specific section of LA FOIP that allows you to give personal information of any student to any third party. And that's the listing of what there are there.
Right. And these next slides are just examples that we've pulled right out of the Act, and we've kind of summarized them so it's a little bit clearer in terms of what circumstances we're talking about. So information can be disclosed about a student without consent if there's a subpoena. For the police, if they're undertaking an investigation. But it's important to actually challenge and see if they're actually conducting some sort of a formal investigation, or if they're just fishing. And what I liked in the health sector is they came up with a form that the officers have to sign, and actually have to cite a section of the criminal code or what have you, and there's a trail and responsibility, accountability built in the event that it wasn't for a proper purpose.
We usually ask them to make the request in writing,
Exactly.
but that's a good idea.
Mm-hmm. Or, as I mentioned before, complying with a different law, like public health, child protection, Ministry of Education reports. And this is, again, where policies and procedures will help guide you in what kind of information can be released. But also, as I mentioned earlier, you can disclose to protect the mental or physical health or safety of an individual. Perfect example. You've done an assessment, you believe a student is suicidal, and then they run out and nobody can find them. Well, disclosure provisions say that you can then contact who you need to in order to protect that child. So if it's the police or the RCMP, you make that judgment call and you release that information. In order to kind of gauge a threshold when it's appropriate to make that call, it's a 3-part test that we've laid out in our Guide to Exemptions on our website. So asking the question, is there a reasonable expectation of probable harm? In that case, the answer is yes. Does the harm constitute damage or detriment or not mere inconvenience? Yes. Is there a causal connection between the disclosure and the anticipated harm? Well, that would be if it was released to the individual. We flip that, is you're preventing the harm by disclosing the information. So check, check, check. document the disclosure, and there you go. And that's an example where you have to act quickly. You know, there aren't time limits placed on disclosure, so sometimes you can take your time. Others, you have to act swiftly. Or in compassionate circumstances. So, you know, if someone has passed away, it's getting in contact with the next of kin, friends, family, letting them know that they've passed away or that they're ill or injured. Some other examples is, and it's the same thing, school division, a local authority can share with government if it's to determine eligibility for programs or services, to regulatory bodies, you know, as I mentioned earlier, if it would reasonably benefit the subject individual or assist in the provision of services. And also there's some language around integrated services I don't have time to go into. There's more details in the regulations. Talk to your privacy officer about it. But programs like that are like hubs, right? Which I think some of us are familiar with.
Vitra, hubs.
Yes,
those things,
exactly. And then lastly on this set of slides is also that the overriding public interest where it outweighs the invasion of privacy to the individual. Privacy interests are of the person. And the balancing comes into place when we think, okay, well, in order to protect the privacy of this individual, others might be harmed. So there are things taken into consideration, and an example is a dangerous offender. You know, the privacy would be keeping that secret, but then the individual may go out and do harm to other people. So then that's when the public interest may override and the information can be released.
FOIP exemptions are discretionary, or at least some of them, not all of them. But there are a number that are discretionary, and when they are, then someone needs to exercise their discretion. So the school division privacy officer or coordinator must be able to show that it exercised discretion in an appropriate manner by demonstrating that they have considered the relevant facts, the pros and cons, and that they entered into this with an open mind, that they weren't biased. Having records demonstrating that there was a thought process involved would be helpful in the event of an investigation by the Office of the Privacy Commissioner. Where there is disclosure, it needs to be consistent with the division's policy and procedures, needs to be appropriately redacted. So consider whether all of this information is needed to be released, as well as documented. So keep a copy of what records were released, to whom and when, as well as a copy of the redactions that were taken and the reasons why, so that it can be used in the future, so it's clear as to what was released to a third party. Where disclosure decisions are made, they should be made by the FOIP coordinator or your privacy head. This is not a decision that it should be made by individual employees. If you receive an access to record request, notify your head or your privacy officer so that the determination of the process can be made. An inappropriate disclosure may result in a privacy breach, may need to be reported to the individual affected, and there could be disciplinary consequences against the employee. So it's really important that you engage your privacy head or privacy coordinator in deciding how and when to release records.
I'm going to talk a bit here just quickly about records retention and disposal. You have to keep records only as long as they're needed for the purpose for which they were created or collected. We actually have some guidance in this area. There's a records retention and disposal guide. It's been approved by the ministry. It's not mandatory for personal information, but it sets out the recommended practice in the sector and is a very good guide as to how long. And your school division may also have an admin policy that addresses this, and will often reference that. So for student records, which is mostly what you'd be dealing with, we generally, the recommendation is until the student is 25 years old. But if you're involved in some fairly serious situations involving sexual assault or physical abuse, those records should probably be retained for a longer period. We suggest 75 years. That may vary from school division to school division. So check with your own school division. You folks may quite often be involved in these situations. Remembering again, and just a reminder, we've already covered this, those records do not belong to the individual professional. Those belong to the school division. You cannot keep them unless you have permission from the division, and we don't generally recommend permission, but there may be some professional pieces that could apply to. And I know that professionals have been advised, oh, you should keep these records in case you're sued. That's something you should discuss with your board and ensure that your board understands what the potential issues are, and they can make sure that the records are retained.
All right, we're getting close to the end. Consent under LA FOIP. For the most part, again, if it's tied back to your mandated programs and services, you don't need it. But if you do, there are two forms of consent that we talk about and that LA FOIP recognizes, which is expressed or implied. And in order for it to be expressed or implied, a number of circumstances have to be in place. The first is that it must relate to the purpose for which the information is being required or requested. It must be informed. That means it's knowledgeable. It must be given voluntarily. You can't coerce it. You can't obtain it through misrepresentation or fraud. It's effective for a period of time. You don't want to have a consent that lasts 20 years, but you don't want it to be too short either, because then you're constantly chasing the individual down to sign another consent form. It can be expressed, which is opt-in, versus implied, which is opt-out. And it need not be in writing, for instance, with an express consent. So you talk to someone over the phone, you verify the identity, you know who you're dealing with, you document it. And then if it's challenged later on, at least you have the documentation to go on. And then if they come in for a visit or, you're having a counseling session, that's your opportunity to get something in writing if you felt it was necessary. So the individual needs to know why you're collecting it, how the information will be used, that period of time, and the right to refuse to provide the information, and the right to revoke consent. But revoking consent is never retroactive. That means that if I revoke my consent today, you don't go back 6 months and try to undo what you did. That's impossible. It's from this point forward.
Well, the school division's policies and procedures are in place to demonstrate what information is required to provide services. So employees should be trained in obtaining consent, so the issues that Diane just raised, as well as clear on what essential information is needed and what's not. Please ensure that people are not pressured or coerced or threatened to give consent.
And we have a resource on our website. It's called Best Practices for Gathering Informed Consent and the Content of Consent Forms. It was authored January 2018, and I think it's really easy to find that under our resources on our website.
And basically this information is a summary of what's in that particular report.
Right.
Remembering again that once you've obtained consent on collecting or creating the material, once it's within the school division, you've got it. You don't need to do it again. The last set of information we want to talk about a little bit is breach. This can be a pretty significant issue, or it can be, if you're dealing with it appropriately, it can be a good learning experience. So the breaches will occur, generally the breach occurs when your disclosure is made to a third party where either there's no consent given or there's no section of LA FOIP that really applies to the situation. In the situation of dealing with the folks that we're talking today, professionals, you're probably not going to, once the breach happens, your job is to report the breach to your LA FOIP coordinator, to your supervisor, who then will work with within the division and often with the Office of the Privacy Commissioner as well to address the breach. So I think that the main emphasis we want to make is don't cover this up, don't think it's not important. The sooner you report something, even if you think it's trivial, report it, have somebody work with you so that what you think is trivial doesn't turn into something that's more significant. And I think that's a very important thing. You want to address these things as soon as possible.
Well, let me pick up there. With the amendments that happened to LA FOIP January 1, a provision was added making it mandatory to report to those affected by a breach, to report to them. Now, is it all breaches? No, not necessarily. It's those breaches where you realize that there's a risk of real significant harm. And that involves discretion, and that should be discretion exercised by the privacy officer or by the head, which would be the director. And And I think as Geraldine was saying, if this occurs to you, you're really wise to report it to the LA FOIP coordinator to get a second opinion as to whether it fits within this. We find that people report things to our office that are not necessarily a real risk of significant harm, but they're just taking the abundantly cautious approach of doing that. It's also hard to analyze exactly what is a real risk of significant harm in this world that we live in of identity theft. Pieces of information that are might seem to you to be rather incident may be the items that others can put together to basically create a driver's license, create a passport, create a Visa card, or whatever purpose they're sort of after. So if in doubt, talk to your privacy coordinator to get a second opinion. The next slide talks about a resource, privacy breach guidelines, a good spot, and that'll sort of take you through what one needs to do. You may or may not have to do this, but if you're a privacy coordinator, you may have to do it. There is another extremely good resource developed a number of years ago, sasschoolsprivacy.com, and you can learn an awful lot on that website about a whole, not just breaches, but a whole series of issues re privacy. So we are now down to questions. You've heard people who do a lot of work in this area, and you've heard that in many instances it's the facts that will determine what to do. If anything, I hope we have convinced you that if you have a situation where you're unsure, that you ask questions of your privacy coordinator, of your director, of your lawyer, whatever the policies and practices of your school board are. It's really wise to ask that question earlier. No one person can retain all the rules in this area. Well, except maybe the three people I'm working with. I know I can't.
No.
But it is really important when you hear something to say, should I ask somebody? And I think that's one of the most important steps. So now that we're in the mode of should I ask somebody, we'll invite other questions.
Parents and students have access to school counselor records even if the division has an electronic documentation program. Wouldn't a documentation program be considered the private property of the school division?
What we think about in terms of information is the information of an individual is their information in the sense of they have the right to ask, to look at, get a copy of that information. The school board has, and that's where probably the better word is, the care and control of that information. The school division takes care of that information, but the individual has the right to have access to that information and get copies of that information. And that's true whether it's paper or electronic, whatever it is. When we get an information request, we look at what's the ed psych, what's the SLP done, is there a principal's file, does the resource teacher have a file, does the teacher have a file, is there a file at central office? All of that information the individual student or parent can access. So everything they have the right to do if it's their own information.
Right, and it's a really formalized process. Like if there's an access request that was made, there's 30 calendar days to sift through the information, sanitize it, if you have to sever certain information because it needs to be withheld, and then a copy of that information. You wouldn't provide direct access to a student or their parents directly into your database, right?
No,
you have to protect the information. So it's that formalized process, or if you know it's information you can routinely release, again, look for guidance from your privacy officers. It might be a lot faster and a lot more informal.
The last one we did was 2 4-ring binders full of printed material off of the system.
Next question.
If a health professional is recorded on video providing educational programming with students with a disability, can this video be shared with other educational professionals on a controlled access social media platform such as Seesaw?
No.
No.
Generally, no. You can, if you record something within the school division, and use it just within the school division and share it with your professionals, that's okay. If you're going to share it anywhere other than because you need it, and I mean share it within the school because the other people need to see it, they might the behaviors might be helpful or whatever. Anything else, you need consent, and our advice would be to get written consent, and that consent should be very clear, as we've just gone through, as to what purpose it is, who's going to see it, who has access to it, how long they're going to have access, and then the person says, okay, knowing all that, I agree, you can now show that to these other people. Get consent if you're ever in doubt. Otherwise, don't show it.
When writing a report to a family with parents that are divorced, it is on the onus of the parent getting the report to share it with the ex-spouse, question mark?
There's no legal obligation to create reports for parents, so I don't know exactly what this might entail.
If there's a report that exists, and it's about the child, both parents have the right to access it if they make the information request.
Yes, but that's under LA FOIP.
Yeah, you can't you can't say I gave it to your ex-spouse, go get it from them if they make the request. So each parent has the right to make as long as they have access.
Yes.
Yeah.
Yeah, and the access rights under LA FOIP are for records that already exist at the time of the request.
That's what I was
Yeah.
making.
Okay.
So we typically will see in litigation that one parent will ask for records relating to the child and hope to get access to the other parent's records. So when we're dealing with family litigation, we have to be sensitive to the fact that some records are mom's records, some records are child's records, some parents are dad's records, and some of them are joint records. So it becomes much more complex, which is why I encourage you to consult with your privacy head.
We sometimes see people saying, create me a record with this, and this. If a school division wishes to be cooperative, they can create that record. The minute they create it, there then becomes obligations to disclose it, subject to LA FOIP. But the Act does not create an obligation to make a brand new record. It deals with records that exist.
Can you discuss how LA FOIP applies to VIRA?
Vitra, yeah. When you're dealing with Vitra, you will have protocol agreements that will involve your partners. That will be part of it. There's also provisions in LA FOIP for information sharing agreements with your partners. Also with Vitra, there's often consent obtained from parents involved for the sharing. So it's following those protocols, getting consent when needed, and in some cases relying on information sharing agreements you may have with your partners. So yes, we can share it there. And also with Vitra, if there's an emergency situation where safety of people is involved, there's some general provisions that allow sharing of information in those kind of circumstances. So we don't want information sharing to be a bar to helping in situations where that's necessary.
The Office of the Privacy Commissioner actually recently released a report on a breach subsequent to a Vitra, which would be available on its website.
Can we give telephone numbers to public health nurses to follow up with students who have not returned immunization forms?
Immunization and health, we have had some discussions with them, and this would fall under the sharing with another government organization in order to provide access to services. Again, share the minimum information required in order for them to do that. We don't deal with the consents to the processes at all. This is just information sharing. So in that situation, if that's the best and only way and the minimal information, then there should be no issue in sharing it. Again, in your particular circumstances, there may be an agreement with your health. Well, there's only one health, so that may be, check with your privacy officer if you have any concerns, but generally, yes.
Section 10L of the regulations specifically addresses access by the Regional Health Authority to this sort of information for children under the age of 7.
That's for registration stuff. But
The College of Psychologists has developed guidelines for psychologists working in SAS schools, December 2017. It is suggested that psychologists need to get explicit consent to review the student's cumulative folder. Does LA FOIP trump the guidelines?
Well, I'm going to let my experts answer, but LA FOIP trumps everything. That has to be your mental start point.
And that's our agreement. Again, this is exactly the situation where once the school division has created the record, if the school now this doesn't mean the school psychologist gets to look at everything in the cumulative record automatically. If there are portions of the cumulative record that the school psychologist needs in order to do their job of providing services to the student, the school psychologist does not, repeat, not have to get consent.
Section 27 of LA FOIP specifically deals with the use of personal information, and we've already addressed this issue earlier in our presentation, and it's quite clear that the use of that information would be consistent with the purpose collected. Yeah. So it's really about determining the range of information to be accessed.
And I believe those guidelines might be under review right now, so we'll have to wait and see.
So if I can just add in that, when I say LA FOIP trumps everything, it's the starting point. And as pointed out, there's a section that deals with this. But generally, as a mindset, if someone else has created some guidelines, you start with LA FOIP, and guidelines cannot override LA FOIP or the regulations.
And this is specific to school division employees. So so we need to be mindful that LA FOIP applies to school division employees.
Can school divisions mandate the collection of PI without parent consent?
In order to provide education services, school divisions require certain information. And there's actually some sections in the Education Act that require parents and students to provide certain information to the school divisions. So yes, in the sense that if the school division requires certain personal information in order to provide the services to the student, yes, they can. But again, this is not a blanket thing to just say anything we want, they have to give us. There are some restrictions on that. I'll give one example is if the student needs an accommodation for medical issues, the student must provide medical information. They have to. That's just the way the law of accommodation works. So in that case, it's not like the school division mandates it. But there are some other things such as age of the student, in terms of being able to know whether they fit within the compulsory education or the right to education. So yes, there are some things, but if you're in doubt, that's something to check with the superintendent.
A high school student under the age of 16, parents are divorced and have joint custody. Dad has a fiance and wants her name and number on the school to use in case of emergency when he cannot pick up his daughter. Mom does not want the fiance's information on file. Which request do we follow?
This is a family law matter. This is something that they can sort out between themselves. But for our purposes, if Dad is going to provide us with this information, it's his information to provide. We would put it on file.
Thank you very much for the extremely good questions. If anyone has any feedback about our style or our approach, too long, too short, all that would be really helpful. Anyway, I think we'll close off now. So thank you for signing in.
Thanks all.
Thanks,
Thank you.
everybody.